Good morning and welcome everyone, and thank you for taking the time to be here today. My name's Julie Wheway and I'm from the Public Education team at IP Australia. We're bringing you this webinar today and we've designed it specifically for small businesses and startups that are wanting to know more about intellectual property and how harnessing the power of your IP can help support your business growth. Shortly, you're going to meet our subject matter experts, Senior Trademark Examiner Patrick Johnson and former Senior Patents Examiner Catriona Bruce. But before we begin, I'd like to acknowledge the traditional custodians of the land on which we're presenting from today, the Gadigal people here in Sydney and the Ngunnawal people in the ACT. We pay our respects to ancestors past, present and any emerging leaders joining us today. We'd also like to extend these respects to the traditional owners' lands that you're all joining from and to other Aboriginal and Torres Strait Islander people who are joining us in this webinar. So we'd really love to know what questions you have, whether you have any burning IP questions. So please please ask at any time via our anonymous platform Slido. You can scan the QR code that's on the screen now or go to slido.com and use the hashtag IPSmallBiz. We'll aim to provide the answers to your IP questions at the end of the session. If we do run out of time, we're going to take them on notice and we'll share the answers along with the slide deck using the email you gave us when registering for this webinar. A note also that we're going to be recording this session and we'll make the video available afterwards. And throughout the session, we're going to be dropping relevant links into the chat that will direct you to our website for the relevant resources and tools along the way. And so don't worry if you miss them though, we're going to send these out with the slide deck also. So please start asking your questions now. So who's IP Australia? We are the Australian government agency that administers intellectual property rights and legislation relating to patents, trademark, design rights and plant breeders' rights. And part of our role as an agency is to increase the awareness of and engagement with the IP system for Australian businesses so that everyone can benefit from great ideas. And at the end of this session, we hope that you'll have a greater knowledge of registered intellectual property rights and how you can use them to protect and grow your business. We're also going to share with you some of our resources that we've developed, especially for small businesses, that will help you navigate your IP journey. So intellectual property, or IP, refers to the creation of the mind, a creation of your intellect. And IP takes many forms. It could be a mechanical invention, a chair design, a medical device, a new style of shoe, could be software or a data set, or even literary and artistic works. IP is an intangible asset, so just as businesses protect their physical property, you should take the protection of your creative output just as seriously. IP Australia's laws provide a legal framework to protect your creative ideas through IP rights. And IP is all around us and it can often be in places we least expect. So think about when you're eating your favourite biscuit, mine's a Tim Tam, you're interacting with the trademark. The phone you use, the car you drive, and even the flowers you grow in your garden can all be protected by various forms of IP rights. That legal protection can help prevent copycats and protect your brand or innovation. On this slide, we have some recognisable examples of registered IP that you can spot every day at home or at work. This diagram here really nicely outlines both the registered and unregistered IP rights system. At IP Australia, we administer the registered IP rights, trademarks, patents, design rights, and plant breeders' rights. The other types of unregistered IP protections are copyrights, trade rights, and circuit layouts. And in separate ways, they each protect intellectual property and are applicable in different circumstances. For businesses, comprehensive, manageable and affordable IP protection may be provided by using a combination of registered IP rights or a combination of registered and unregistered rights. For instance, you might decide that the initial best course of action for your business is a trademark and a trade secret, and then down the track, seeking a patent protection might be more suitable for your business as the business evolves and grows. So what's the benefit of getting an IP right? Across a range of indicators, the contribution of SMEs to innovation and small businesses to innovation in Australia has been really increasing, and we've been seeing this for now a number of years. There's research coming out of our Chief Economist's office that shows that all things being equal, startups that file IP in their first years are twice as likely to experience high growth. Small businesses that file for patents, trademarks, and design rights are more than twice as likely to achieve a high turnover growth than their peers with no recent filings. And SMEs that own IP rights are on average 3.5 times larger than their peers with no IP rights, and they pay a higher median wage. Also, when it comes to investment, international studies have estimated that patents and trademarks can increase an investor's estimate of a startup's value by about 20%. So now we're going to shift focus and do a bit of a deeper dive into our most popular registered IP rights in Australia: trademarks, design rights, and patents. And we'll begin by introducing Patrick Johnson, a senior trademark examiner here at IP Australia. Over to you, Patrick.
Thanks, Julie, and good morning, everyone. So I get asked all the time, what exactly is a trademark? Well, it's often called a brand, and a trademark is your identity. It's what's used by customers to differentiate your goods and services from those of your competitors. And it's not just a brand name or a logo. It could be a jingle in an advertisement. It could be the slogan in your advertising. It could even be the design of your packaging. Really, it can be any sign that customers can use to differentiate your business from others. It can include things like phrase, color, sound, smell, shape, logo, picture, movement, aspect of packaging. Any combination of those things can be a trademark. A registered trademark can be a really valuable asset for your business because it provides you with the exclusive rights to use, to license, and to sell the mark. It can also be a valuable marketing tool because it actually grows in value as your business grows in success. So on the slide, we've got some examples of registered trademarks. We've got Arnott's, which is a word trademark. We've got an example of the purple color that Cadbury has actually managed to trademark, a specific shade. And we've got an example of how logo and words can be used in combination to make a logo trademark. In terms of the duration of protection for a trademark, the initial protection lasts for 10 years, but if renewed, trademark protection will last indefinitely. And yes, we've actually got the very first trademark that was registered over 100 years ago, still registered in Australia. So I'd like to talk about a really common misconception, and that's that a registered business name in Australia will stop people from using similar business names. It doesn't, and only a trademark allows you to control your business name or logo in the Australian marketplace. In the same sort of nature, getting registration of your business name doesn't mean that you'll necessarily be able to also get the registration for the trademark. The two systems are quite separate and different rules apply. Now I'd like to talk a little bit about design rights, which is the other right that my group looks after. So a design right protects the overall visual appearance of a new and distinctive product. So for example, it could be a Dyson vacuum cleaner or Apple's AirPods. And on screen, we've got some examples of famous designs for a chair, a mixer, and a barbecue. So a design right aims to protect the visual appearance of a whole product that has physical and tangible form, it's manufactured or handmade, and is produced on a commercial scale. So you have to keep your design a secret until you have applied, and that's a little bit like patents, which my colleague Catriona will talk about in a moment. Even posting a single picture on social media can make it more difficult to obtain a design right and then enforce it as well. In terms of applying for a design right, it's a two-stage process in Australia. You don't have to do both at the same time, but you will need to do both if you want to take the steps of enforcing your design right. In terms of the lifespan of protection, it's a maximum of 10 years. There's an initial 5-year period, and then it can be renewed for a further 5 years. And that's design.
Thanks, Patrick. I might just get you, your mic's a little bit burbled, so I might just get you, while we throw to Catriona to talk to us about patents, I might just get you to maybe adjust your mic if possible. That would be great. Thank you. So now we've just heard from Patrick around trademarks and design rights, but it'd be great to hear more a little bit about patents. And so now we're going to meet Dr. Catriona Bruce, a former patents examiner at IP Australia, who's going to share with us a bit more information about patents. Over to you, Kat.
Good morning, and thank you, Julie. So a patent provides exclusive rights for a thing or a way to make a thing. So that could be a device, a substance, a method, or a process. And that has to be new, inventive, and useful. So on this slide, we've got 3 well-known examples of patented items that you're familiar with. Google Maps, the the cochlear implant, we're actually still on design rights that I can see, and also Wi-Fi. So I'll just give you a moment. Can everyone else see the slide, or has it just not progressed for me at this moment? It's just on design rights at the moment.
I have put it forward. There might be a bit of a lag.
There's probably a lag.
Yeah,
okay,
with the number
thank you,
of people on
Julie.
the call.
Sorry.
That's okay. There is a
It's
lag,
fine.
probably with the sheer number of people. Apologies, everyone.
Absolutely. That's all good. Look, the patent slide will come momentarily. There it is. And a patent protects a product that's distinguished by the way it works, or by its composition, or its means of operation, or the method it's been produced by. When granted, the patent gives you an exclusive commercial rights to your invention, which is a monopoly. In exchange for that monopoly, you have to give a full disclosure of the invention so that others can reproduce it and grow and make new innovations. So it's the monopoly for the full disclosure. It's really important, as Patrick mentioned, for designs, that you shouldn't share your idea too soon. So if you're applying for a patent, it has to be new. So no one should have seen it before worldwide. So if you've advertised it on Facebook or on YouTube, that could be a reason that you may not be able to get a patent. If you want to discuss your idea with employees or business partners or potential collaborators, therefore you need to have them sign a confidentiality agreement or a non-disclosure agreement. So the other thing is about things that can't be patented. So no matter how ingenious or unusual they may be, we can't patent artistic creations, mathematical models, theories, ideas, schemes, or purely mental processes. They must have a practical application. So the patent application options that we have on this slide, we show there are different types of patent applications possible for Australians. And it's important to be wary of the nuances around timing and life cycle of each of these types of application. We can give further details on the IP Australia website, and also get that advice from IP professionals like a registered trademark attorney. So the first one I'll talk about now is a provisional application. That sets your post in the sand, as it were. It's a marker. It secures a priority date, the first date that you're claiming that you made the invention, and it's like a placeholder. And you have 12 months from the date of filing your provisional to decide if you want to file a complete application. And with a provisional filing, there's limited information available to the public, only really the title and the inventor names, not all the details of your invention. So it's still very much covered by a secret type of situation. It does not give you full patent protection. It is just that place in the ground, and it's not published, as I said. But you do need to have that to mark that first date. Then you've got a complete standard patent application. You can just jump straight to this, but many people use the provisional first. That's necessary for patent protection. In Australia, you have to file a complete standard patent application, and it gives you the right to take legal action against others who might be using your invention in Australia without your permission. It also allows you to license someone else to manufacture your invention on agreed terms or to use it themselves, and it allows you to sell your patent as well. You can also sell that patent, that IP right. All of these options here, the standard or provisional and the international, which I'm going to come on to, they can be complex, and we strongly recommend that you consider legal assistance to help you apply and meet the requirements. There's lots of information on the IP Australia website and YouTube channel if you want to know more about IP for your small business. But I will now move into the international or patent cooperation PCT application, because many people in Australia are keen to capitalise on overseas markets. And a PCT application is a process administered by the World Intellectual Property Organisation. If you're planning to obtain patent protection in multiple different countries or jurisdictions, this option can help streamline the process because you put one patent application in with the PCT, and then you can then later choose which countries you want to file in using that process. And the PCT application gives you an indication of whether your patent might meet the requirements across all the different countries involved. Now, it doesn't itself give you protection. You still need to file complete applications through what's called national phase entry in each country. And again, we suggest very strongly that you get legal advice to protect your business interests. It's not just about the IP and the managing the filing process, but it's also about how your business strategy and IP fit together, particularly with the international markets.
Thank you, Kat. Okay. Thank you. That's really great. That's a really great high-level summary. Obviously, patenting is quite a complex area, but really appreciate your insights today. So now we're going to move into the scenarios. I can see there's some questions coming in on the chat through Slido. So thank you, everyone. And we've got lots of time at the end to get to these. So thank you for these great questions. What we're going to move into now is the scenarios. We've got two small businesses today, two small business scenarios that have joined us today. And so thank you again to Patrick and Kat for your great introductions to trademarks, design rights and patents. So our two scenarios today, we've got two small businesses who are looking to grow and how they're going to consider IP in their future growth planning. So first up, we've got Liz from Top Style Hairdressing. Welcome, Liz. Can you tell us a bit about your business and what your plans are for the next 12 months?
Sure thing. Hi, everybody. I have two busy salons in Sydney and they've got a great reputation. I'm looking to expand the business into Southeast Queensland. I do have a registered business name under the name Top Style. Do you think I need a trademark to protect my brand?
That's a really great question. Patrick, I'm going to throw to you for that one.
Thanks, Julie. Hi, Liz. Before I go in, I'll just check. Am I coming through clearly now?
It is better. Yes. Yep.
Excellent. All right, well, that's a good question and one we get asked all the time, Liz. It's really up to you whether you want to register your trademark, but it does help to deter imitators, and it makes it a lot easier if you need to defend or enforce your trademark. For example, if you want to send a cease or desist letter, or heaven forbid, you want to take someone to court, it makes it a lot easier. You also really don't want someone else to register your trademark before you do. Often if that happens, then you'll need to rebrand, and that could be a really expensive exercise for any business. So really, the sooner you get a registered trademark, the better protected your trademark will be.
Great, that sounds great. How would I know if somebody else was using the name Top Style or something like it?
Yeah, so it's always a good idea to check your trademark before you apply for one. What I'll do is I'll show you our free online search tool called TM Checker, and I'll use your trademark as an example if that's okay. All right, so my screen should be coming up now. This is our tool called TM Checker. And so what I'll do is I'll put in your trademark, Top Style. Now, the next step that I need to do is I need to select the goods and services that you provide. So this is a really important step because trademarks are only protected for the goods or services that you select and not other goods and services as well. So you're a hair salon, so hairdressing services is probably a good place to start. You can see we've got a lot of different options here in class 44. I'm just going to grab a few of those just for the purposes of this example. It's also good when you're thinking about registering your trademark to think about what you might want to expand into in future. You can actually add that into your application at this stage as well. So let's just say that further down the line, you're thinking about releasing your own line of branded shampoos. So I'll add those in as well. So I'll select a few options here. And you should see that down the bottom, the classes selected has increased the total cost from $330 to $660. And that's because the fees for trademarks are based per class. So I'll go on to the next stage, and this will run some AI checks in the background. Okay, so we've got a couple of warnings here. The first one here is distinctiveness. That's about whether or not your trademark is something which is distinctive and unique enough to be protected as a trademark, or whether it might be something that other traders in your industry should be free to use. Now, in this case, that's probably come up because your brand name Top Style, well, top is a descriptive term that means the best, and style is obviously a pretty common word used in your industry. Now, that doesn't mean you won't be able to get the trademark. What it does mean is that if you apply for the trademark, it's likely that an examiner will raise an issue and ask you to prove that your trademark has been used enough to become distinctive and that consumers recognize it as being your particular brand and not just a generic description of your services. The next warning that we have here is similarity. So that's about similar trademarks. So you can see we've got a few ones here. A lot of these aren't that similar, but this first one here, Top Style, that does look fairly similar. But before you get too worried, let's have a look at the details. Okay, so we can see here all the details, including the goods and services, and it's registered for Class 21 servingware for the presentation of food. So that's pretty different to hairdressing services. So in trademarks, there's an important principle, which is that you can have the same trademark being owned by different people if the goods and services they're being used for are different enough. So the example that we always use is Dove. It's a brand of chocolate and a brand of soap. Those things are in such totally different industries that consumers are pretty unlikely to get them confused. So you can probably still get registered trademark for hairdressing services compared to servingware for the presentation of food. So that's TM Checker. At this point, what you could do now is you could play around in the tool, read through some of the information that we've got, great FAQs in there and a few videos that explain things in a bit more detail. Or if you're feeling confident, you can go ahead and put through an application via the tool.
Thanks, Patrick. Liz, did you have any more questions around trademarks?
Thanks, Patrick. That was great info. I'm just wondering, how do I actually go about applying for one, and what is the time frame and how long does it take?
Yeah, so you can apply it in a few different ways. The first way would be continuing through TM Checker. And if you do that, you'll get a response from an examiner within 5 business days. You can also put in a standard application. That's great for people who need to access our advanced options or are a bit more familiar with the process. Or the third major way would be to go through an IP professional. Now, obviously, that's going to be the most expensive way, but it's also going to get you some great advice and help ensure that you're applying for the right thing and you get the right protection in place. In terms of how long it takes, so it's going to take at least 7 months from application to registration. And that's because we have to wait for international applications that might be coming in. And we also need to advertise your trademark for opposition purposes for 2 months. And that's where other interested businesses or parties could potentially oppose your trademark and object to it. Now, that sounds a little bit scary, but rest assured, less than 5% of applications actually get opposed, and even fewer of those are successfully opposed. I might just go over a few other things that you should keep in mind when you're applying for your trademark. So certain things to avoid putting in your trademark, any scandalous or offensive terms that can attract an objection, certain signs that are protected by Australian law, for example, the words Anzac or Olympic, crests and coats of arms, or the Red Cross symbol, for example, and things that are really generic. If your trademark is only consisting of terms that are really generic, like a geographic name or a common surname, those might attract objections. It's also really important to think about the ownership of your trademark. You need to make sure it's being owned by the right entity that has the rights to the trademark, and that entity has what we call legal personality. So that's most commonly an individual or an incorporated company. And then finally, one of the most common questions I get asked is, what should you apply for? Should it be a word mark? Should it be a logo mark? Maybe a combination of both. So that's a really complicated question, and something that's great to get some legal advice about. But really, it depends on lots of different factors, like how you use the trademarks, whether the different elements are really important for your brand, whether you always use them together, those sorts of questions. What many businesses will do is they'll apply for a combination of things. So they might apply for a word mark and also a logo mark, or maybe a combination of the two, or all three together.
Hey Liz, that's really great info, and I think that's going to be really helpful for you. I'm just wondering if you had any other questions about intellectual property.
Yeah, absolutely. So that's the first time I've actually heard of a trademark. So what other registered IP is there?
Yeah, so we've already talked a little bit about patents and design rights. There's also plant breeders' rights as the other registered one. That's more important for people like farmers and nurseries. It's also really important to keep in mind the unregistered forms of IP. So copyright's a really big one. We don't deal with that, but the Copyright Council of Australia has got some great information on their website if you'd like to learn more. And also trade secrets can be a really powerful tool for protecting your ideas and your intellectual property. So IP Australia's got a tool on our website called Choose the Right IP, and you might want to have a look at that to help you decide.
I think that tool would be really good for me to check out because we actually have an innovation in the salon that we've been thinking needs protection. We've developed a hand washing basin for people to use with limited mobility that also uses less water. Do you think there might be another IP right that I could use to protect the basin?
Yeah, okay, that sounds like a really great product. So I guess if there's a technical advancement in the way that the basin works, maybe a patent is an option. Or if the overall appearance of it is unique compared to other basins in the market, then a design right could be a good choice. At this stage, it's probably a good idea to think about talking to an IP professional to help you decide the best strategy for protecting your basin. We've got another business case coming up actually that's going to look at patents more deeply, so you might want to stick around for that one.
Sure thing, that sounds great. Where else can I go for more information about IP?
So our website, IP Australia, www.ipaustralia.gov.au is a great starting point. If you prefer to talk to someone, you can also give us a call on 1300 65 10 10, or you can just Google IP Australia Contact Centre and that will come right up. I should probably point out that as a government agency, IP Australia can give lots of information, but we can't give any specific advice for your situation. So if you need legal advice or business advice, you're going to need to hire an IP professional. We've talked about this a bit, and it's definitely going to increase the costs to you if you have to hire an IP professional, but it'll give you the absolute best chance of success.
Thanks, Liz, and we're going to wish you all the best as you're branching out into sunny Queensland.
Thanks, Patrick.
So next we're going to move on to Kai. We've got Kai joining us today. Kai's the founder of Green Friend Tech Innovation. Kai, I was wondering if you could tell us a little bit about your business and your plans for growth.
Sure, thank you, Julie. My name is Kai, and I have a company called Green Friend Tech Innovation. We're a small startup business designing and manufacturing components for eco-friendly appliances such as energy-efficient fridges, ovens, and solar-powered water heaters. We had this idea about combining our engineering know-how with AI to radically disrupt the world of everyday appliances and reduce carbon emissions. These appliances are supported by a program that monitors and manages power usage using a new device. So far, it's unique technology, and we've kept it a secret with just a few key people knowing. I have a question about patents. So what legal requirements are there to get a patent?
Kat, this sounds like a great question for you.
Thanks, Julie, and thanks, Kai. It sounds like a great idea and particularly aligned with our government's priorities on renewable energy and reducing carbon emissions. So I'm really glad to see you doing this. Thank you. So with a patent, the basic requirements that you need to meet in order to be granted a patent are that it must be new, inventive, useful, and of suitable subject matter. So new just means that the invention must be different to anything done before. When checking this, we search the entire global patent databases and also not patent information, so things like journals, magazines, newspapers, Google, for identical and similar inventions. That means, as you have done, thank you, you need to keep your invention a secret before you apply for your patent if you want to be able to protect it with your patent. If your patent's already visible to the public, and we see this quite a lot by accident with people with Facebook posts, for example, even if you've published that yourself, it's no longer new. So just emphasising, if you need to talk to others about your idea, you need to be sure that they will not disclose your idea to anyone else. And you can use a non-disclosure agreement to formalise that, for example. So the aspect of inventive means that the invention must go beyond what's obvious given the normal progress of technology. And useful means that it can be readily made or used within an industry for a purpose. And the invention needs to do what it says on the box. It needs to do what it says in the patent description. The aspect of whether it's patentable subject matter is covered by manner of manufacture, and that's a rule that can be complex and is assessed on a case-by-case basis. So an easy way of explaining it is that you can Only patent inventions that have a tangible form and can be manufactured, and yours do, but there could be some questions around the use of AI. So further information on this is available on our website. And if in doubt, always consult an IP professional and they'll be able to help you protect your interests in your business in the best possible way. You also need to describe fully your invention and provide illustrations of it where appropriate to meet legal requirements. And that's that part of the trade-off between having a monopoly and a full disclosure. And you might want to hire a patent attorney for this as well, a specialist in the area that will help meet all the requirements to have the Australian patent granted. And they would also potentially advise on the international market.
Thanks, Kat. That's really great. Kai, did you have any more questions about patenting for Kat?
Yes, thank you for describing those requirements. So how long does it take to get a patent and how long does it last?
Yep, a great question again, but it's also quite hard to answer. It depends on the technical nature of the invention, the options you choose along the way, the patent examination required, and if there are any legal obstacles. So once the patent application does meet all the Australian legal requirements, it will be accepted and then granted. And generally, you're looking at a minimum of 1 year for a standard complete patent application to be granted from filing to grant. Some cases it can take several years, and more details of those dates are available on the website. Once granted, protection of your patent in Australia can last for a maximum of 20 years, and in some cases with an extension of term for 25 years for pharmaceuticals. And you do need to renew that on a yearly basis for the 20 years. Before you start your application, it's really important to search in case someone has come up with the idea before and you didn't know. So there are many tools available for searching patents. Each has its own benefits. IP Australia offers a free patent search tool, and you can use that to identify active patents in Australia. For example, to see if there are any existing patents which may overlap with your invention. And if you're looking to search what's out there more broadly and globally, to check if your invention might be new, there's also things like Google Patents, WIPO's Patent Scope, IP Lens, and the European Patent Office's Espasnet, and social media, just to name a few. But it is a very technical area. Patent language is very challenging, and so getting a professional to assist you with that might help you find things that you haven't known about before.
That's very useful to know. If you don't mind, could I ask how much each patent costs?
Yeah. Again, this is a sort of piece of string question. Much like maintaining a car, there are ongoing costs to have your patent researched and officially examined to move through the patent application process, and that can cost tens of thousands of dollars. Firstly, in fees with IP Australia, but also if you get a patent attorney, in legal costs, which are generally, that a thing that people tend to do, particularly with more commercial. The more commercial they are, the more important it is to consider your whole business interests and to get that patent attorney advice. So in terms of the IP Australia fees, lodging an initial patent application starts from $100 for a provisional patent and up to several $1,000s for full protection. A standard application fee for a standard patent is $400, and there are additional fees along the way with an annual fee to keep your patent active and a search examination request fee and additional fees for amendments, international searches, re-examination and certification. And those are IP Australia fees, not included in any patent attorney fees. We really do suggest that you read background information application forms carefully before you fill in your patent applications. And SMEs can also contact IP Australia's Patent Case Manager service for assistance. And the patent case managers are people who are dedicated to helping SMEs and taking them through the patent application process. You can request a case manager by just calling our customer contact service centre on 1300 65 10 10 on weekdays between 9 and 5, and they'll call you back to provide information on the patent process and to connect you with a case manager. If you do wish to engage a patent attorney, that will help you apply for and draft your patent application correctly. It will increase the costs, but they can also provide you advice to make sure you're hitting the mark for what you need to protect and for your business strategies. They have tertiary qualifications in science, technology, and engineering and IT, which helps them understand the technical aspects of your invention. And they also have legal qualifications for IP, which means they can understand and explain to you the necessary legal requirements for securing patent protection. And there's on our website, there's more information on engaging a patent attorney.
Thanks, Kat, and thank you to Clarissa, who's kindly sharing all these links as we go. Kai, I was just wondering, did you have anything else that you wanted to know from our IP experts?
Yes, actually. So we've been talking to a company in Germany about partnering our technology with their products. So how do I go about collaborating with another organization, and how do I protect my IP in these situations?
Fantastic. I'm really glad to hear that, because your products will have a very important market overseas in Europe and other countries. So many businesses want to sell or license their IP, create a business, or collaborate with an industry partner to bring the product to market. That's one of the essential steps, is getting that IP and then taking those next steps in commercialization. By securing the IP rights in those markets that you want to operate in, or that you think might be valuable in those collaborations, you can protect your idea from imitation and prevent competitors from using it in their own commercial activities, and also attract investment. And this includes overseas manufacturing, marketing, and perhaps even clinical trials or testing if you're in that field. So before you collaborate, think about whether it would require any background IP or third-party IP, whether you'll develop new IP together, how to manage ownership and licensing rights, and negotiate early with the collaborators or potential collaborators using non-disclosure agreements. And also consider which countries you might need to have protection in. And Austrade can also help exporters prepare for overseas sales. So our website has got some useful options if you're planning to look for a business collaborator, including a page with tips on how to commercialize IP and drafting a contract or non-disclosure agreement.
Thank you, Kat. I appreciate you sharing those great resources in the chat as well. So I'm curious, if my company wants to sell overseas or export, how do I secure international IP?
Yep, lovely. Thank you, Kai. So an Australian IP right only covers you in Australia. With that, exporting for services or products, you need to apply for IP rights in each target country. And that could be a country where you might be manufacturing, where you might be doing more further research or clinical trials, or where the product might be going into that market. So it's a broad range of different target countries. So that you can protect your trademark, invention, design, or plant variety in most countries, either by applying for each country individually or using the international system like the PCT we talked about earlier, or Madrid system for trademarks. And so Australia, with 170 other countries, belongs to an international union for the protection of industrial property, and that there's also a Paris Convention that helps protect your IP in other countries and allows you to claim the same filing date in your overseas application, provided you file within 6 to 12 months of your original application. And the filing time frame depends on the type of IP right, but that is also an alternative to the PCT route for patents. So once again, I just recommend, particularly with any international matters, seeking advice from IP attorneys who can help you coordinate that and ensure protection of your ideas and your business interests.
Thanks, Kat. That's really great information. Kai, was there anything else that you wanted to ask from us?
Thanks, Julie. So where do I get more information on IP for new businesses like Green Friend?
Great question. So I'm hoping everyone can see this slide now on the screen. We are really proud of the resources that we've developed at IP Australia for small businesses. You can see, hopefully you can all see a QR code, which will link you to our website, where we have a page for small businesses, support and tools for small businesses. And just to highlight a few of the things on that page, that there is there to help you as a small business on your IP journey. So there's a link there to our TM checker, which Patrick fantastically demonstrated earlier. We've also got some really great fact sheets on IP basics and also information on our patent case manager service. And as Kat really fantastically mentioned earlier, that we provide a service for small businesses where you can be connected with an IP Australia subject matter expert who can be your single point of contact to assist you in your patent application process. So I really encourage you to spend some time on our website. There's some really great tools and resources there for small businesses. The other thing that we're really proud of is this Small Business Big Dreams fact sheet. And to help small businesses find the resources that they need, we teamed up with other government agencies to create this fact sheet. And it outlines a typical business journey, transforming a business idea to a market-ready venture. And this fact sheet provides links to free programs and resources available from government to support small businesses at every step of the journey. So it includes things such as checking readiness to start your business, identifying and protecting your IP, collaborating with other businesses, and even accessing funding opportunities. And it can provide information on tax and superannuation obligations and developing marketing strategies and ensuring compliance with workplace laws. Clarissa's going to put the link to the chat to this, and I really encourage you to take this away with you and use this as a bit of a tool on your business journey as well.